Mr. Chief Justice, and may it please the court. My name is Gabriella, and today I represent the respondent in its response to the petitioner's Sixth Amendment claim. Today we ask this court to decide that Bobby Bronner's Sixth Amendment rights were not violated when out-of-court statements were admitted against him. We ask for this ruling on the basis of two key issues as stated in Ohio v. Clark, this court's most recent decision on the Confrontation Clause in our record. First, Ohio v. Clark states the most recent definition of the primary purpose test, stating that statements are testimonial when created with the purpose of creating an out-of-court substitute for trial testimony, and that in order to determine that primary purpose, this court must consider all of the relevant circumstances of the situation in which the conversation occurred in which the statements were created. There are four key factors that I will discuss today that constitute all of the relevant circumstances of this situation in order to demonstrate that the primary purpose of the conversation between Andy Somerville and School Resource Officer IL was not to create an out-of-court substitute for trial testimony.
We only get to this issue if the Olympus statute is constitutional, right? The one that bars 10-year-olds from being called to testify.
Respectfully, Your Honor, the issue of whether or not the statute is constitutional is not before this court today, and the petitioner has said as much. The first factor that
Counsel, but we could, that issue's not, perhaps it's not before us, but the court could choose to remand this case with instructions to the Supreme Court of Olympus to explore that issue, could we not?
I suppose this court could, but in this case, as we're arguing here today, the petitioner has not challenged the constitutionality of the statute, and so we will not respond to any challenges.
But the Craig case, doesn't the Craig case state that that the trial court is to do an analysis, case-specific analysis, as to whether causing the minor to testify would be traumatic to the minor?
Well, as the petitioner stated, the Craig case involves a child witness who was actually considered available to testify in court, but was testifying through the use of a special procedure. In this case, the Olympus statute declares Andy Somerville completely unavailable to testify, regardless of any special procedures that could be used to mitigate whatever any special interest the state had in creating that statute in the first place.
Is it possible that statute was passed because the state of Olympus recognized that testimony of kids 10 and younger is inherently untrustworthy?
Rather than untrustworthy, part of what the state could recognize when passing such a statute as this is that children rarely provide statements that are going to carry the weight of testimony in court because they don't understand.
But isn't the government largely relying upon a statement of just such a minor that you're now saying perhaps the state of Olympus recognizes is perhaps untrustworthy?
Again, Your Honor, rather than untrustworthy, the word that we should use here is that the statement by the 8-year-old child is the 8-year-old child does not understand that if he were to provide testimony, it would be used to potentially convict somebody.
Might not recognize the importance of his statement.
Yes, Your Honor.
For instance, which makes it, in my mind, less trustworthy. But yet the government's relying upon that in large part to convict this man and put him in prison?
Your Honor, what the government is relying upon is the use of that hearsay statement through Officer IL's testimony. The state and the petitioner can cross-examine Officer IL and determine through the cross-examination of him whether Andy Somerville's statements were reliable or not.
Was Officer IL cross-examined?
The record doesn't indicate if he was cross-examined, but it's assumed that such a statement would be cross-examined by both sides. And if it wasn't, then any challenges that the petitioner brings forward are potentially less credible.
But they didn't get to cross-examine the child?
No, Your Honor. Andy Somerville was declared unavailable to testify in court. In addition to Andy Somerville's role as a young child in this situation, not being able to comprehend what primary purpose he comes into a conversation with, the The court should also consider what role Officer Ayel played in this case. The petitioner contends that Officer Ayel was acting as an agent of a law enforcement officer set on collecting testimony from this young child when he conducted an interrogation with him in this room. However, as a 911 operator can function, even though they are not law enforcement, as an agent of the law, Officer Ayel can function as an agent of the school in his school resource officer position, which he was performing the duties of on the day in question when Andy Somerville came to provide these statements to him. Ohio versus Clark asks us to examine what Officer Ayel was doing, what his role was in the context of the relationship between the person providing the statement and the person receiving it, that is Andy Somerville, and School Resource Officer Ayel in this case. The record indicates that the relationship between Officer Ayel and Andy Somerville was much more similar to a student-teacher relationship than that of a citizen-police officer relationship, like those in Crawford versus Washington and Hammond versus Indiana, where the police officer and the person providing the statement had never met before. Andy Somerville was familiar with Officer Ayel, and in providing his statements to him, he was asking a trusted ally he was confiding in a trusted ally about something that was concerning to him, and certainly what Andy Somerville was confiding in Officer Ayel about was concerning. The third factor this court should consider is the formality of the statement and the formality of the setting in which the conversation occurred. Andy Somerville provided these statements in Officer Ayel's office, but in a school where he was very familiar with the setting, a school where he had attended for more than 5 years. The setting of this conversation was nothing like the formal station house questioning in Crawford versus Washington or the battery affidavit in Hammond versus Indiana.
Counsel, it's been a few years since I've been in school, but I'm pretty sure as an 8-year-old, when I went to the principal's office, I thought it was pretty formal.
Formality is different than the context of a situation where you're providing a testimonial statement that's going to be used in prosecution. Whether you recognize that there's gravity to what you're saying or not, which I'm sure Andy Somerville did as he was talking about something rather serious, the fact of the matter is that unless he was providing these statements with the intent of creating an out-of-court substitute for trial testimony, the statements are non-testimonial. The fourth factor that the court should consider and that the petitioner has addressed is whether an ongoing emergency existed at the time that the statement was given. Because Officer Ayel was not acting as a formal law enforcement officer, this factor carries less weight as in Ohio versus Clark, and further, as the court says in Ohio versus Clark, citing Michigan versus Bryant, and whether an ongoing emergency existed at the time a statement was given is not the touchstone of testimonial inquiry into the Confrontation Clause of the Sixth Amendment.
Counsel, you're basically arguing here that the statements of an 8-year-old child heard by an SRO and repeated as proof at trial, that those statements are sufficiently trustworthy and reliable, that they may be relied upon to basically be the only evidence of guilt for a felony conviction. Isn't that what you're saying?
What the state argues is
Isn't that what you're saying?
Yes, Your Honor, in an indirect way, if I may explain. Officer
Please.
Ayel testified about what he heard from Andy Somerville in court. It's assumed that those statements were cross-examined, given that he testified about them in court. The jury heard those statements and heard them be cross-examined, and then convicted Bobby Bronner on the possession of child pornography. The jury decided that those statements were reliable enough to convict Bobby Bronner.
But no pornography was ever found.
No, Your Honor, but in this case, the jury decided, based on the cross-examined testimony from Officer Ayel, that the statements were reliable. That's the question.
The unexamined statements of young Andy.
Yes, because they were hearsay admitted through the testimony of Officer Ayel, but Officer Ayel was cross-examined.
Is there
in those
anything
statements.
left of the hearsay rule after this case, counsel? If we find for the state of Olympus here, is there anything left of the hearsay?
In what way do you mean, Your Honor?
We have, in this way.
Well, Your Honor, there is still room for statements, my time is about to run out.
Please continue.
There's still room for statements to be deemed non-testimonial through the use of the factors that I'm addressing today in the primary purpose test. But what is most important is that in this particular case, it is clear that Andy Somerville was not providing the statements with the primary purpose of creating an out-of-court substitute for trial testimony. Therefore, those statements were non-testimonial and can be admitted without prior cross-examination of those statements. And it is for that reason that we ask this court to affirm.
Let me ask one additional question, if I may. What if Andy was mad at the officer, because the officer had been mean to one of his buddies, and just lied to him, just made something up, just lied to him? Or what if he was mad at his stepfather? That's even more appropriate. Let's say he was mad at his stepfather. You know, a lot of times stepkids don't like their stepfathers. So he just made something up, right, and told the officer. There's no opportunity for the defense to explore that with Andy, or to find out if he had problems with his stepfather, if there'd been some issue, if his stepfather had, spanked him or disciplined him, or if there was some reason that Andy might have to lie about his stepfather. There was no opportunity for the for the defense to explore that, because they didn't get to cross-examine Andy, right?
Well, though I imagine they would not be able to explore those sorts of things through cross-examining Andy himself, I'm sure that they could cross-examine either Petitioner Bronner, they could cross-examine Officer IL, or Andy's mother, any other friends that he had. There were other opportunities for them to test those sorts of theories if they did have them.
Thank you.
Thank you, counsel.